Sorry
Good.
about that, everybody. I will just put myself on mute while Nina's talking. She's doing most of the talking today. Nina, it's so great to see you. We didn't have our first hello, but hi to everybody. Thank you so much for joining. Sorry we're a couple minutes late. Nina, I wanted to announce that I finally got these first 30 mugs. So for our next coffee and law, you will have one in your hands as well. So I know for anyone, oh, you've got your Gowling. I haven't got a Gowling mug yet, so I want one. But thanks everybody, and also welcome to winter time. I don't know where you are, but we are tomorrow expecting 8 to 10 centimeters of snow. So if you're in the Toronto area, get your shovels out. Because you will very much need them. And before we get started, we actually have a lot of new people joining us today. I just wanted to talk a little bit. We have an exciting announcement at First 30. We're launching your onboarding buddy in the new year. And this is a platform that answers all of your new hires questions about your business. So if you want to ever chat to me about it, by all means, give me a call. We're offering, or send me an email. We're offering some free pilots on that. So I'd love to talk to you. It's pretty exciting. And here's this is a cartoony version of what it will look like, but your new employees can ask any questions about your business, about your brand guide, about how to file their first benefit claim, anything and everything, and it will have all the answers to speak to them or in text as well, and it works in multiple different languages. So happy to chat to you about that. And those of you who know us well know that we also have a fantastic outplacement program that's really growing in popularity. So we'd love to work with you. We are always disappointed when businesses have to downsize, but if you do, you'll see our pricing is very, very reasonable, and our services are all the same as all of the other outlet placement suppliers that you've worked with. And one of our recent clients realized that they could have saved $11,000 in 1 month with 4 participants working with us. So you can see kind of the pricing comparison. There's a lot that you could do with that money. And we have great success rates. So 90% of our participants are back to work within 3 months. So again, always happy to talk to you. We are a WeBe certified business. One of our clients, Hyundai, actually sponsored First 30 to be WeBe certified. So if you're on the call, we're very grateful to you for that. And it's been a kind of exciting development for us this year for sure. With all of that, I am going to stop talking and I'm going to introduce to any of you who don't know her already, though I feel like she's a famous. I want to say 2 things. Nina, 2 things. I was just at a fantastic talk she gave. Actually got to see you speak twice in the last few months, Nina. Once at Gowling's Legal Update, and then once at Disrupt HR recently, and you were just phenomenal. But 2 things I want to say. Nina is very good with the law in general when it comes to employment law. If you are not joining us from Canada, these might be hints to what you should look at, and maybe Nina, you have some clues as to, I know in the past you've shared, but I wanted to make clear that you do operate out of Canada. That's important for anyone joining from the US to know. And I also just wanted to, before I give you the mic, I just wanted to remind everyone, remind you, Nina, to give your disclaimer. So with that, I will stop and I'll let you introduce yourself as well. And I'll mute myself so we're not echoing.
Well, thank you, Amy, and thank you all for joining us at Coffee and Law. 2024 is just about to end, and 2025 is about to start. And I'm already typing letters, and I'm getting all the dates wrong because I haven't done the mental shift to 2025 yet. This is obviously very high-level generic advice, and it's mostly based on the law in Ontario and what I would say the English-speaking parts of Canada. Quebec has a different regime. And I personally am not insured to practice outside of Canada, but we have a huge firm, and we have offices all through Europe and Asia, and we have best friend relationships with fabulous lawyers in the United States. So if you're ever having that, what I call that sort of gut feeling that you need to talk to a lawyer, even if I'm not the right person, I'll find you somebody who is good. That's my commitment to you, and I don't charge to make that introduction because I know That's a service that we can do. It's like, doctors know the best doctors, dentists know the best dentists, and lawyers know the best lawyers.
I'm going to interrupt you there, Neena. The best lawyers, like you, know the best lawyers.
Yes. Okay, I'll take that. That I can pay. So I have done a short slide deck, Amy, just to sort of keep me on track about some of the things that I want to talk about. But I'm really going to encourage questions. So if you're thinking about what should I do in 2025 and it's not on my agenda list, that's fine. A couple of reasons why it's fine. A, Amy and I have a real good set of resources we can help you with. And two, the audience here, Amy, is really good. And sometimes we've had these great discussions occurring in the chat room where you and I may not have somebody on our Outlook contacts, but the audience does. So don't be afraid to ask a question, even if we don't have the answer. I think that one of our 66 participants will. So with that, I'm going to start. And
I'll be in the chat, and I'll be also in the Q&A, so I'll keep an eye on that. So if you want to pop your questions, it's always easier when you pop them in the Q&A if you know where to find that. But if you put them in the chat, I'm going to keep my eyes open on that too. And since I won't be driving slides, it will be a lot easier for me today. So Neena,
okay,
are you going to share yours?
I'm going to share my screen.
Perfect.
So just tell me when I am sharing my screen.
You are sharing your screen.
So I thought because it's Coffee and Law, instead of doing the boring Gowling's, corporate logo, I would find a great picture of a perfect cup of coffee, because that's what I'm having after lunch. And, year end is very busy. I've talked to a number of HR people. It's busy because you're doing final payroll. Some of you are also making difficult compensation and headcount decisions, which will be implemented before December 31st, because that's the fiscal year, and it's a busy time. I wanted you to start thinking about the beginning of 2025 and what we want to do for that. And because I think it's really important that we plan ahead. And I wanted to talk about some general themes. First of all, there's no question in my mind that we are getting increased compliance scrutiny. One of my clients told me that in the Barrie area, which is just north of Toronto, the Ministry of Labour hired 50 new hires that will predominantly be doing compliance audits. And if Barrie gets 50, you're pretty sure that Southwest Ontario, Toronto, Eastern Ontario will be getting a commensurate share. The other trend that I notice is we're still struggling about return to office. It's a bit like the genie was out of the bag. Once workers proved that they could be effective with a bit of technological support from home, they started thinking about, do I really want to, spend more money on commuting, more time? I need nicer clothes. As one of my person says, I don't use deodorant on the days that I'm going, that's too much information, I don't need it. But there's just the amount of time and energy that is devoted to commuting, particularly in larger centers, really makes a difference. And so we'll have to talk about that. And three, and this is part of the increased compliance scrutiny, but it's also, I'm noticing that if employers do something wrong in the paperwork, they're getting hammered for it. So those are kind of my themes. But again, you can ask questions that don't fit in those themes, because this is really intended to be your year-end Q&A. But then I'm always paranoid that no one's going to ask questions, Amy, and it's like high school, nobody has questions, and then, that prevents it. So we've talked about
usually we have the opposite problem. We have so many questions. But listen, don't hesitate. Ask your questions as we're going, and I will interrupt Neena. She loves being interrupted by me during these sessions.
Yes, I do.
Yeah.
So one of the things I'm going to really ask you guys to look at is, are you doing vacation pay right? In the good old days, which is like when I started work, it was sort of, okay, you have 2-3 weeks vacation, you take your vacation, your salary is continued, everybody's happy, well rested, and really delighted to take their vacation. In Ontario, but actually across Canada, accounting for vacation pay has become really complex. It's easy if somebody earns the same amount of money every week, no overtime, no bonus, no commission. Then they take their 2 weeks off, you pay them for that 2 weeks. You're kind of balanced out. As soon as somebody works overtime, gets paid a bonus, that for maybe a very discretionary Christmas, like $200 gift certificate or something, you need to worry about whether or not your vacation pay calculation is. Ontario law also put in a new upgrade. Those Working for Workers Act, 1, 2, 3, 4, 5, we're now up to 6, by the way. You now have to actually have a written agreement how vacation is paid. In Ontario, you're supposed to pay vacation pay as a lump sum when a person takes their vacation. Rarely does a business do that. Typically what they do is they continue the salary or compensation during the vacation period, and they use the vacation pay as almost like a trust fund that then is used to apply to that time off. Well, that salary continuation way is technically offside Ontario's rule. So you need to have an agreement that you can pay it by way of salary continuation. If you've got bonus and commissions, you should be reconciling every year. You should be looking at, this person earned $100,000 in base salary, $20,000 in bonus. Have I paid the right amount of vacation? And do a reconciliation. Your pay stubs need to show person earned 2 weeks of pay, then they went on vacation. Those 2 weeks are vacation pay. Otherwise, it's really hard to prove to the Ministry of Labor satisfaction that they got their vacation. So
Neena,
this is complicated math.
I do have a question, and I'm wondering if anyone else has a similar question. You might have said it before, but I just want to clarify. Now, what size business does this apply to? Is this all businesses? Is this 25 employees or more?
Everybody. And this is why it's problematic.
Yes.
Yeah, I know. It's problematic because the amount, like most people either write their own, if they're mom and pop, they just give checks or do direct deposit. Otherwise, they use ADP and Ceridian. The problem with ADP and Ceridian is that these were American programs designed for American payroll systems. In the States, as far as I know, there is no mandatory vacation pay. So whatever vacation you pay, that is effectively voluntary, a gift, if you will. And so there's no statutory requirement to keep track of it as precisely as they require in Ontario. And we now are facing class actions where employment lawyers, worker side, are saying, you've been paying vacation pay wrong for 15, 16, 17, 20 years, as long as the employee has been wrong, and we want you to pay the correct vacation pay plus interest for all your employees, including the ones that are no longer with the company that you have to go chase down, because that is a breach of the statute. And
now,
the Court of Appeal.
Have some questions coming in. The first
okay,
question
just let me finish this slide and then I'll go
sorry,
go through.
Neena. Yes, of course.
Yeah.
We can.
So the Court of Appeal, normally we have a 2-year limitation period in Ontario for everything else, but the Court of Appeal has determined that the limitation period here should not run from when the employee knew how vacation pay was being paid, but from the date on which they realized it was being paid incorrectly, which means the date that they spoke to the Ministry of Labor or the date they spoke to a lawyer. So the limitation period never really ends up. And so, what I'm saying is I'm not sure I can fix 15 or 20 years in the past, but we can at least try to get the vacation pay right starting January of 2025. So you were saying that we're getting some good questions.
We are. One question is this federal law as well?
I'm not as familiar with federally regulated companies. This is definitely provincially regulated companies.
So that's a good one
but
to
I
check
would,
on.
Yeah. So if you're federally regulated, I would still look at it really carefully, because the Feds only are 10% of our economy, just so you know. They're some of the largest companies, and then, interprovincial trucking and admiralty and maritime, and those are smaller companies. But what I would say is the Feds have often followed Ontario where they don't have their own law, so I'd be very careful.
Okay, so thank you. What counts for bonus purposes of calculating vacation pay? Would once a year amount would a once a year amount based on company department sales total count?
So yes, absolutely. So those once a year bonuses do count, and what I recommend is that you tell everybody and get them to agree that for bonuses, you'll pay the vacation pay at the time you're paying the vacation pay, and you will show, let's say, I'm going to say, you have $1,000 bonus, and you will show vacation pay as $60 on top of that. And there's nothing saying that your calculation rates can't be adjusted for the fact that you have a 6% or 4% vacation. So, and let's say you could say to me, we could do the math, and we could have $1,000 total split between the bonus and the vacation pay. And that is the safest way to avoid large class action suits. You need an agreement, and I put these into my employment agreements, that vacation pay on bonuses are paid at the time that the bonus is paid.
Wow. Okay. So if we pay our employees by salary continuation for vacation pay, do we still need to show it as vacation pay on the pay stub?
I would
And for
recommend,
context, they're salaried employees.
yes, I would recommend that you do that, because salaried employees are not exempt from the obligation to prove you've paid vacation pay. You may remember that Amy took 2 weeks in July off, and those were vacation, and you just paid it by way of salary continuation. And you may have a memo somewhere to that effect. 15 years from now, when you're enjoying your retirement and some pay clerk is trying to figure out whether they paid vacation pay correctly, they're not going to have that on the payroll system. So you've got to have some way to make it easy to prove at the end of each year, whether it's a year-end reconciliation, or it is a memo to file, or it's some documentation showing John Doe took vacation, Amy took vacation, these are the vacation days, and she has been paid out her vacation. You've got to be able to keep track. You think it's not a lot, but, most companies run on, they're happy to make, a 8% or 9% EBITDA on sales. Well, if you have a 4 or 6% payroll mistake, that can really start to eat into that. So I'm just saying, let's be careful.
Wow.
I
knew vacation was so complicated. Like employees
I just want to
don't know.
I'm sorry. Marianne Pelletier asked about Quebec. If you want to email me and I'll send you my email, I'll get one of my Quebec lawyers to answer that question. But I do not want to guess on Quebec regulations, because I'm not called to Quebec. And then
Neena,
there's a
I'll
really
make sure we get your, if you want to maybe type your email into the chat, that might be helpful.
Sure, I can.
Yeah.
Yeah, I can, let's see if I'll just do it to everyone. Let me just send to everyone, see? And I'll give you my slides after we're done this, Amy, and then we can.
Okay, great. I'll send
it'll
them
be
out
there
with the
too.
Recording as well. Can the vacation pay continuation agreement be in a policy, or does it have to be in each employment agreement?
So the agreements, so whenever the Ontario Employment Standard says an agreement with an employee, it's got to be a specific agreement that is signed by the employee. It cannot be just sitting in a policy somewhere. So the agreement with respect to you get paid your bonus and vacation pay on bonus at the same time, that has to be in an agreement. Doesn't necessarily have to be in the employment agreement. It could be a side agreement, just like we have side agreements for overtime averaging. That's another example, or excess hours. Those are side agreements, but you need to have something signed. It can be signed digitally, and it can be done through a digital system, but you have to show that you have it.
We've
And
got sorry, I've got some more here in the Q&A, and then I'll go back to the chat unless there's something you wanted to answer in the chat right
sure,
now.
no, yeah.
This is a complicated one. With varying vacation pay requirements across jurisdictions, how can we ensure compliance when managing employees in multiple regions, particularly scenarios involving remote work, prorated entitlements, or carryover policies? What are this is a big question. This could be a whole webinar. What are the key legal pitfalls to avoid? It's a great question. It's a big one.
So the thing is to think about it in advance and understand what the rules are, and actually do an annual reconciliation to make sure, and it's not just vacation, it can be stat holidays, it can be vacation, and it can be payroll. So you want to make sure that you are 100% or as best 100% that you can be on payroll compliance in general. And so we've had some people who say, well, I don't want to break down the vacation pay on pay stubs. Well, I don't want to pay my taxes, but it just doesn't make it right. Like, I mean, if you read the Employment Standard Act, it tells you have to tell people what they're getting paid for. And so I'm not sure why the CEO doesn't want to show vacation pay on it. I think some people don't show the accumulated vacation pay because their system. That's okay. But when people are being paid out their vacation pay, they have a right to know that's what it is. And so a couple of things, and these are, I didn't think we are going to do it. I'm going to move on. I'll take one more vacation question.
Okay,
when you have people,
yeah, I do have one more here that I think is probably going to apply. So senior employees of a company accumulate their vacation time year after year. I see this all the time when I was working on corporate side because they don't have time to take vacation. Should HR encourage, ask them to have their unpaid vacation payout by March of the following year?
So one of the things I'm going to strongly encourage you to do is make sure that they take at least their Employment Standards Act minimum vacation, so the 2 or 3 weeks under the statute. The rest, you can have various policies. You do need someone to look at it. But yes, you either have, and in some provinces you can't. So for example, in BC, you can't really have forfeiture language. In Ontario, theoretically, you can. But I like the idea of paying out the vacation, having them release any claim for vacation prior to that time, so that you have a record of doing, but then that again requires a bit of a math reconciliation at the end of the year or end of the quarter to say, where are we on vacation? And it says something about the culture of a company when the senior employees, hey, look, and I don't take my vacation, so I'm not casting, I'm not casting the first stone, but it does say, do we need to think about our vacation policy? Is it realistic? Are we staffing properly when people can't take their time off? Believe me, questions I ask.
One of the biggest things in all of this, because having worked with so many different companies and at so many different companies, when employees understand the why, they do have a easier time, although not always, because vacation is always one of those sticking points. They do have a better, they are better at being more agreeable when they have the why. This is a complicated why, but if you can simplify it and share it with them somehow, it is so helpful for everyone concerned.
I'm not going to spend the same amount of time on statutory holiday pay, but there are similar questions that arise. Most of us were just happy in the good old days to get a paid day off, to stay at the beach or do whatever. But the technical rule is your statutory holiday pay is effectively the average of your last 4 weeks of pay divided by 20. And so if, again, you get bonuses, commissions, variable pay in that previous 4 weeks, your stat holiday pay may be wrong. So it's not as big as vacation pay, but it is something to be thinking about. There's real scrutiny over overtime and excess hours. do not make the mistake that just because someone is salaried, they're exempt from overtime pay. The Ministry of Labor is looking very carefully as to who truly is managerial, supervisory, and executive, or a professional, to make sure that they are exempt. And a lot of us do oh, she's salaried, so I don't have to worry about overtime. That's not the test. A lot of times people want management lieu time. You have to have a written agreement. A lot of times people want overtime averaging. We certainly do. Again, need written agreements, and in Ontario, we need to refresh those agreements every 2 years. So these are, I guess what I'm saying is we need to pay attention to our payroll practices and not same old, same old. And maybe what you do is hire an HR consultant to come in or an accountant to come in. What I am predicting for 2025 is the Ministry of Labor will be paying attention on health and safety, employment standards compliance, and CRA, the tax authorities are coming in to do audits on employee classification. So if you have a lot of what I call those disguised employees who are on independent contract agreements, be really careful, because unless they have their own company, it is highly likely that they might be found to be employees, which means you will have penalties and back orders to pay CPP and EI. And I know in Ontario, about 2 years ago, the Ford government had a really nifty exclusion clause. Somebody's a business consultant or an IT consultant, and they're registered, and they earn $60 an hour or more. You could exempt them from the ESA. So that's a nifty contract exemption. However, just because they're exempt from the Employment Standards Act does not mean the CRA is bound by that contractual exemption. So I've had a case where they're exempt from the ESA, but Revenue Canada has come in and said, all those independent contractors are de facto employees. You should have been withholding taxes. You should have been remitting CPP and EI, and you didn't do it. So again, be careful of those.
One quick question before we move on. If someone's terminated before a stat holiday or they're laid off, but the holiday falls into their notice period, they're 2 weeks, should they be paid? Do they get paid for the holiday? That's a very specific one, but I'm sure it happens all the time.
Yeah, it does. I just, I'm not telling you that it's right, but the practice is they just get paid the 2 weeks, and that includes the 1 day stat holiday, right? So let's say the Monday was a stat holiday. I don't deduct the stat holiday, but I don't pay extra for the stat holiday.
Thank you.
But you're right. I mean, there could be a good argument that they should get paid 2 weeks plus the stat holiday, and I honestly don't know the answer to that one. Now, the Ministry of Labor has a 1-800 number, and they are good about answering those types of technical questions.
That's a really good, that's a good hack, Neena.
Oh, I have it. You know what? I'll try to put it in the chat if I can manage to do the slides and manipulate
do you want me to? Well, I have to do a little bit at the end, so you have to give me 5 minutes.
I'll do that.
In your 5 minutes, you put it in the end.
I will. So one of the things that we've noticed is return to office, surprisingly, like theoretically, although I'm going to just tell you, I had COVID 3 weeks ago. So it's not gone yet, or it's still around. And by the way, I'm telling you, go get your, I don't know, I'm on my 8th COVID shot or whatever, but just get it, because this version of COVID is kind of nasty, actually, nastier than some of the other ones. Anyway, but even though we are, supposedly more than 2 years, almost 3 years out from the worst of COVID, we are struggling with return to the office. Some employers are struggling to manage remote employees. They miss the teamwork, the camaraderie, the brainstorming. As I said in my opening remarks, employees hate the lost time. I saw a U.S. study saying the expense is the equivalent for an employee of weekly grocery or monthly groceries. So one employee's commute would cost roughly what their groceries for a couple would be. And it also is lack of flexibility, because if you're spending, 45 minutes half an hour, hour and a half each way commuting, it makes it much harder to pick up kids, deal with parents' appointments, and so on and so forth. And there's a real trend of people quitting or demanding more money if forced back to office, or people claiming constructive dismissal. So if you are thinking of more strict return to office requirements, expect all of those and create a strategy about how to introduce your policy carefully. One thing managers need to be very careful about is if there are requests for exemptions. The knee-jerk tendency, and I dealt with this in Disrupt HR, the knee-jerk tendency is to say no, but a lot of those requests could theoretically be protected requests because they are based on family care, elder care, health issues. And so your managers need to be trained to refer them to HR and not do that knee-jerk no, and essentially analyze those requests so that you're not later on being faced with a claim of favoritism, which is what
And that's
often
such a
happens.
hard one, isn't it, Nina? Because sometimes you have someone really advocating to work from home and really pushing back on it. And then when push comes to shove, and it's like, well, you have to return to office for these amount of days, then they might be in a position where they're like, okay, now I have to disclose why I really needed to work from home. And it's human nature to question, like, well, why wasn't this what you said before? Right. So there's like there's just so many human components to this one that
And you
don't
have
always align
people,
perfectly.
and they don't, because I have a case where, and you have to keep requests for accommodation confidential. So now you have a situation where in a group of 10 people, you have 2 or 3 people who have legit accommodation reasons why they are not being required to come back to the office on a regular basis. Well, all of a sudden, you've got somebody who doesn't want to come to, maybe doesn't have as compelling a reason, definitely inconvenient for sure, definitely more expensive for sure, but doesn't have a protected ground under the Human Rights Code. And she simply says, well, you're just being favoritism. It's just favoritism because other people don't have to do it, and I'm not going to do it until the rules are applied evenly. It's not very satisfactory to say you've got to trust us that there are reasons why exemptions are made and why we're not making an exemption for you. It's really a difficult communication. It creates a certain amount of trust that it requires a certain amount of trust to make that system work. Now, I'm very pleased to say in our own office, we have a group of, legal assistants who are fabulous. And there are a couple who have very legitimate reasons why they can't come into the office. Like the choice would be quitting their job or coming into the office because their health issues are so profound. And because everybody likes each other and everybody trusts each other, we cover for them, and it works out okay. But if you don't, in larger organizations or larger teams, teams that are 100 people, not 5, 10, 15 people, it's very hard to manage. But creating a reputation that every request is dealt with in the same way and scrutinized in the same way goes a long way to avoiding complaints about favoritism. Or worse yet, you are discriminating against me because I'm of a certain race or religious background, when in fact it has to do with elder care and child care.
Yeah. I have a question here that I think is a good one. How much notice is required to return to the office?
Well, like everybody hates it when lawyers say this, but this is truly an it depends answer. So, and the reason I say that is because if you hired somebody on the basis that they were going to be a remote employee, and now that you're saying they have to go to return to office, you may have a constructive dismissal situation. So you want to work through that differently than if you had somebody who always worked in office, during COVID started working remotely, has always been told that that's a permanent or an interim solution, not a permanent solution. And in those cases, I like to be reasonable because they're going to have to make alternate arrangements for, let's say, childcare or transportation. So I like giving everybody 8 weeks. And that coincidentally happens to be the notice under the Employment Standards Act. So if they're going to claim constructive dismissal, I can at least get rid of the ESA claim by saying, yeah, we gave 8 weeks notice. So you're saying it's constructive dismissal, that we gave the 8 weeks notice, so there's no issue.
Okay, that's a great benchmark for people to use for sure. Okay, so there's a question here about someone returning from a mat leave and they want to work from home when their job was one that was in person before. What are the duties to accommodate as the concern is around not having proper childcare? That's a really interesting one.
So what I would say, I would not make that a permanent accommodation. I think I would give people time to find childcare, but if we were to exempt everybody who's got childcare issues from the requirement to work from home, you'd be surprised how few people would actually come to the office. So I would say, give them people time, make sure they're on the right waiting list. Large corporates in Toronto are actually creating spots with various childcares in the downtown area to say, we want to have at least 3 spots because we know we'll fill them easily. So there are strategies that you can enter into. Quite often it's an expense issue. It's not like they can't find childcare, but it's so expensive that it's not, the equation about working becomes very difficult. I'm not sure that needs to be accommodated because childcare is expensive. I know Trudeau's trying to do something about it.
Yeah.
Thankfully, my son's 23, so I don't have to worry about it. But, it is, but I would not make that a permanent exemption. I would make it very clear that the
one
exception is.
very short anecdote. My children are now teenagers, but when they were young, I had so much trouble finding them childcare. And I did have an employer that had a childcare location downtown. But here's the thing I learned, Nina. Never put your child in daycare near your office. Put them in childcare near your home. Because if you're sick, you have to take them downtown.
Oh, yes, that's a
Yes.
very good
Or
piece.
if you want to
Yeah.
have a day off, you're still doing the commute back and forth. So anyway, that's my little piece of advice for anyone who's planning children and daycare on the call. We do have a really good question. Can you ask for proof that the employee is on childcare lists?
Yes, I would say that you can ask for that in a very polite, non-confrontational way about what have you done and can you show me that you've done it? Because I don't want to have a situation where they say, oh, you're discriminating against me because you're not trusting me at my word. That's part of your process. Your accommodation policy should make it very clear that there should be some effort to document the need for accommodation, and you should also look at whether or not this is the kind of job. Some jobs can be done from home. There are other jobs that there are significant portions of which cannot be done from home. And so I had a situation where, yes, there are things that can be done from home, but there's reception duties, mail, when we used to have Canada Post, mail duties, cleaning up the conference rooms for the next meeting. So this was a sort of an office facilities role. And this person didn't want to come in because they said, well, other people can do that. And the point was, you've got to have a legitimate reason under the Human Rights Code not to come in, because nobody wants to come in. So you can't just dump the job, portions of the job you don't like, when it is an integral part of your job. Now, for our finance people, honestly, they could probably do their entire job sitting on a beach chair on some, beach. Like, honestly, because they're not interacting with humans. But so it would be much harder for me to refuse them a accommodation versus somebody who's doing office facilities. As you know, Amy and I were having problems getting audio. I sent out an SOS to our IT person, and he physically came. You can't do some of that work from home.
I'm going to take accountability. That was my mistake.
It's okay. I just wanted to answer one question about organizational vacation policies in an organized or unionized sector, that would I would want to look at the collective agreement to see what's going on. But typically, it depends on your relationship with your union. Sometimes I don't want to open up a can of worms. Sometimes your relationship with your union is really good, and you can honestly say, we just want to clarify this policy. We've been told that it has to be put in writing, and can we get into what is called a memorandum of understanding with the union? And what I have observed of the Ministry of Labor is they are, while they're still doing health and safety audits quite rigorously in unionized workplaces, they are less concerned about payroll audits in unionized workplaces because they're relying on the union to complain if there's a problem, right? So that makes, and in some ways, having the union there, it's harder for the union to say, oh, we didn't know what our rights were. I mean, the whole purpose of a union is to bring forward union rights. So a lot of the problems I'm talking about, those class actions, they're not in unionized workplaces, they're in non-unionized workplaces. The final thing I wanted to cover is, your paperwork matters. So there's some policies that should be reviewed on an annual basis. One is workplace harassment, anti-bullying policies and procedure. And what I want, there's two things I do. One is I ask if there have been any complaints or concerns, because those complaints and concerns demonstrate that there might be a gap. Not always, but it might be a gap. And that could be training, that could be your policy itself, how you recruit, how you promote, and even physical safety. So we had a harassment complaint. It was more of a workplace violence complaint, which dealt with the physical security around one of our buildings, right? So those are really, good things to review. Your Joint Health and Safety Committee should have a look, and you should look at your policy. Interestingly, Ontario does not prescribe a cadence for training. Like, it's not a training should be done once a year once every 2 years. I recommend that you refresh and redo your training once every 24 months at a minimum. I just think it's a good touch point to remind people that there are certain behaviors that your workplace will not tolerate. And so there's two, if you had 25 employees or more, you already have or should have electronic monitoring and right to disconnect policies. If you didn't have 25 employees but will have 25 employees in January, then you should be creating these policies. And in any event, if you have the policies, you should be reviewing them. I have found the electronic monitoring policy needs to be reviewed because the pace of change of technology is so fast, and some technologies that weren't implemented a year ago or 2 years ago are now being used effectively to monitor productivity or attendance, hours of work, and you need to sort of talk to your IT people as to the types of technologies you have that you might not even realize you have. So, and in another workplace for security reasons, they put in cameras. Those cameras can also be used to confirm whether or not somebody really came into work as clocked in or whether they got a friend to swipe in for them. So we had to update our electronic monitoring policy to say, even though we rely on our payroll systems, our cameras can be used to verify data in our payroll systems. So that is all I have prepared. I don't know if we have any more questions or if we've gone through all of them.
Oh, we do have more, and I apologize to anyone whose questions I wasn't able to answer. We weren't able to answer. Well, I can't
Oh,
answer
yeah.
them. I mean, I can try, but you did answer the question about unionized environments. When you say refresh agreements every 2 years, do you mean employment contracts? If yes, I know the answer to this, Neena, because we've done so many of these. If you could be if yes, what could the premise for this, especially to inform employees as to why it's being done?
Okay, So when I said about refreshing agreements every 2 years, that was specifically with respect to overtime averaging and management lieu time, because there's a time limit on those agreements. So you need to, if you have overtime agreements, excess hours, lieu time, you should probably refresh it every 2 years. The question that's being asked by Lovell is actually a much more interesting one, is you had an employment template. Your lawyer tells you that that template isn't good anymore or isn't as effective and needs to be improved, and you want to use the new template. The new template's great for new employees, but what do you do about your existing employees? So here's the answer. You can't force people to sign a new agreement unless you essentially give them a choice. And the choice is something like, if you want this promotion, you want this raise, you want these better benefits, you want a better educational allowance, whatever. If you want that, you sign this agreement. Best time to get a new agreement signed is when you are giving people a true promotion. So in Gowling's, legal assistant to law clerk 1, law clerk 1 to law clerk 2. These are true jumps in, responsibility, compensation, and prestige. The idea of, I'm going to fire you all if you don't sign this new agreement doesn't work. It wrecks morale. It's not a good HR technique. Lots of people will quit, and I think there's an argument that's under duress. There's a really good case which says if you're going to do that, you have to be willing to provide them with proper notice. So you can say Jan 1, 2025 to a whole bunch of employees, if you want to work here past Jan 1, 2026, you have to sign this new agreement. Otherwise, you're all fired. You may still have Employment Standards Act obligations of severance, too. So I think that we could do a full seminar on new agreements and consideration in the new year. All I'm saying is, mine was really those agreements with respect to excess hours, overtime averaging, management lieu time, the ancillary agreements that the Employment Standards Act allows you to have, right?
Yeah. Yes. And in a moment, Neena, would you mind to just stop sharing so I can start sharing? Because I have a few other announcements to make before we leave. But there was another really good question here on electric monitoring. Does the fob unlocking the door for entry, does that include the fob?
Well, yes, it could, because if you are using that data for anything more than entering the building, and sometimes people do, right? We do it for security reasons. Who was in the building when the theft occurred? When somebody says they started work at the building at 7:30, were they in fact in the building? So it could include the swipe card that you use to get into the building, right?
Yeah. Yeah. Okay.
Good, for
I
sure.
just have one more question that I wanted to answer, and it's going back to our vacations, but it's from a good friend of mine.
Okay.
So for independent contractor rulings by Revenue Canada, is it complaints driven or determined through an audit? In other words, how do they find out there is non-compliance?
So it is both. It is rarely a complaint-driven process. And the reason I say that is independent contractors typically want to be independent contractors, right? They like the ability to try to at least claim certain expenses that I don't think employees are allowed to claim. So it's rarely complaints driven, and it's often on a routine audit. They'll be auditing something else, and then they come across this.
Okay. All right. Well, that's that's hard to get away from then. But I guess
It
that's
is.
kind of the point. Well, Neena, as
Kind
always, now everyone, I want you to know that I keep asking. I said to Neena, I'm like, people are asking for a 2025 session already. I tried to convince
okay.
Neena that she should start a Coffee and Law podcast, and I'll be her little sidekick. But I know how much work it is, so no pressure, Neena. But it seems that there's a
Okay,
lot
we'll
of
talk
demand because
about it.
Yeah.
Yeah, we'll talk about it.
Yeah. So if you do want to chat about onboarding or outplacement, I'm going to reach out after this session, and you're most welcome to ask me any questions you might have. And there's no pressure. It's always good just to ask the question. I think Kamara is in the chat as well. If she's not, no worries. I will be sending this to you soon. But you can join our next webinar in the new year. Peter and I are going to do a joint session. Thought it'd be fun to kick off the year with some retention, onboarding, and succession planning. So we're going to be doing that. So you'll have the link probably in the chat there to join. If not, you can join I'll send an email out after this and you can join that way. I also want to let everyone know that we're going to send the link, so we'll send the link, but there was something else I was going to send you. Now I can't remember what it was. Sorry, you'll see an email from me. And then new year, new podcast. It's not a coffee and law. Sorry, everybody. But I am starting a podcast. If you're in HR and you're thinking of starting a consulting firm for HR, this is a great one to tune into. There's a YouTube channel. I just started it. You'll be one of very few to start off with. But as you know, this First Start is actually my third business. So I know a lot about starting and running businesses, and I just love to help other entrepreneurs. And so I'm going to start this venture. It will actually be recorded as well on video, but also anywhere you get your podcast. But that will be in the new year, just starting all the recordings now. So there's some great topics that I hope everyone can benefit from. And I want to wish everybody a really happy holiday season, whatever you're doing. I hope you get a chance to relax, take some of that vacation. We know we know all the regulation around it now, so make sure you make the most of it. But Neena, a special thanks to you. You're always amazing. I love doing these sessions with you. And next time we do one, you're gonna have your little First 30 mug.
I will. Can I just say one thing I forgot to do? And I'm actually, we have a free, it's more case law oriented. So today's seminar was more compliance oriented, statutory oriented. We're going to do a year in review of all the key cases that have changed employment law. That's a free seminar by Gowling's. I'm going to try to put the invite list into the chat, and I'm going to also ask Amy when I send out the slides to send out the invitation. It's my colleague Mark Jocelyn from Ottawa, Andrew Bratt in Toronto, myself, and the lovely and phenomenal Elisa Scally, who keeps us organized. And it's an hour and a half, and we are going to go through really fast. So I'm hoping I can at least virtually see some of you at that webinar, and it's next. I'm just desperately trying to get the date of it.
When? Do you know? Is it next year? You said?
No, it's like it's either the next. Let me just get the date.
Okay, you know what? I think we should wait, Neena.
It's December 11th.
Can you put the registration in the chat right now?
Yep, I'm going to do that right now.
Okay, we'll just wait because I don't know when the replay is going to go out, and I don't want anyone to miss it. So we'll put it in the chat right now so you can join that session for free. You can also sign up for Gowling. Will it be part of your mail out that goes out as well for Gowling?
Yes.
So look for where you can sign up for Gowling's mailing list. They don't overwhelm you. I'm on their mailing list. So that's a really good option so that you can stay in touch with the team, because you're always doing these really great sessions, and it's really good to get the invites.
And they're always free, and then you get the replay as well, which I think is really nice. So then even if you can't attend the session, you can do what I do. Full disclosure here, I don't always listen to my colleagues when I should be. I just put it in the background when I'm doing lunch or something, and I listen to it then, because sometimes these are really good topics for me, right?
Neena, did you add it to the chat?
I am just doing it right now because I had to go.
Neena's so talented. She can talk and search and be typing in the chat all at once. I have trouble
There you go.
Okay, perfect. Okay, I'm going to leave this up for a minute. And in the meantime, you are all great for joining. It's so nice. I kind of went through the list and I saw so many familiar people, some friends, some clients, some people who are always joining these sessions, which we always love to see. And so if you haven't clicked on the link in the chat yet to join Neena's session, and whenever it is,
I think it's December 11th, so it's coming
coming up
up.
soon.
It's coming up soon,
Yeah.
thank you. Cassia is lovely. She actually puts in the date for
Date.
me because I'm so useless. I can't even remember the
Oh,
date. So
thanks
that
everyone for the help there. And I'm so sorry if we couldn't answer everyone's questions. I did see more than we got to, so I apologize for that. But thanks again for joining. Thank you to Neena. Have a great holiday. I'm excited to catch up with everyone in the new year. Take care.
hey,
Bye.
hey, bye, Amy.
Bye. And as soon as I figure out how to, exit, I will. Okay, I will. I figured it out now. Take care. Bye.